Ladies and gentlemen, thank you for joining us on the Investing in India series webinar today. This is the eighth webinar of the series focusing on dispute resolution. Investing in India series is curated specifically for our existing and prospective foreign investors interested in entering into and enforcing their agreements in India. Today's session, of course, is focused on an enforceability standpoint. However, the series as such aims to provide insights into various aspects of transactions and deals in India. My name is Sneha Janakiraman. I'm a partner practicing international commercial arbitration and commercial litigation based out of the Delhi office of the firm. The agenda for today's webinar is up on the screen. We will aim to take as many questions as possible during the course of the webinar today. Please feel free to share all of your questions on the chat box. However, if time doesn't permit us to respond to all of them, rest assured we will get back to you with responses. You will, of course, also receive the recording of the webinar, the speaking notes as well from the session today. Without much ado, let me introduce our speaker for the day today. All of you will have received his resume along with your registrations. Ravi Tej is a partner practicing dispute resolution based out of our Mumbai office. Ravi Tej also specializes in commercial disputes and arbitration and deals with complex commercial disputes and cross-border matters day in and day out. Ravi Tej is very well placed to take us through the webinar today that focuses on various enforcement risks. Without further ado, let me hand over to Ravi Tej.
Thank you. Thank you so much, Sneha, and thank you for setting the context for today's discussion. As you said, I think we'll try and sort of cover as much as we can from a disputes point of view. Sort of trying to focus the next few minutes largely on five broad issues. The first, obviously, is the overview of the dispute resolution process in India. How are the courts set up? What's the overall lay of the land in that sense? The second is what are the options that are available to a foreign investor coming into India? The second are what should be practical considerations in cross-border disputes. From it again, more from a foreign investor point of view. Four is to look at the recent trends and reforms that have come in to the Indian litigation and arbitration space. The idea being to address the elephant in the room, which is that is India even a place you want to get stuck with litigating? And then at the end, try and conclude the discussion with a few takeaways from what we discuss over the course of the discussion. I think the idea is that to also sort of place forth for you to understand that, look, as things have progressed commercially in India, even the legislature sort of progressed to try and make India an easier place to do business in that sense, improve the overall image and perception that courts and the arbitration setup in India is not bad. And obviously keeping in view that eventually we are, as a country, looking to become an arbitration hub internationally, and also we'll through the course of discussion at some point touch upon the efforts that the legislation is bringing in to try and make that happen. I think with that we can sort of proceed to discussions around what it is that we want to address here, right? We all know the dispute resolution is at the end a very critical aspect of contract enforcement, and it's critical that at the stage of drafting of the contracts and at the stage of conceptualizing the transaction itself, parties at some level do spend some time and energy in sort of deciding on what should be the ideal dispute resolution mechanism. What that does is that when things progress into a dispute, as and when or if at all that they do, there is some amount of legal certainty and predictability on how that process sort of works and moves. That also eventually in turn helps managing commercial risks, because parties are aware of what is it that they want to do, how is it that they want to resolve it, and once they know that, they also have a sense of how much time or what are the the overall lifespan of that process looking like. Obviously, once you plan ahead, you're avoiding the pitfalls of contract enforcement at a later stage as well. And of course, once if your contract builds in the process clearly and coherently, you're also reducing costs and time in the event of a dispute, which I think eventually plays down to the critical question of is litigation even worth it, and if at all, is it worth it involving Indian parties, etc. Right? I think that's something that we'll try and hope to give you clarity on by the end of the discussions as well. I think to the next slide, please. So I think first and foremost, to understand or to plan for it, it's important to sort of also get a sense of what uh, the dispute resolution mechanism structure is in India. So I think first and foremost, let's address the courts and tribunal system. In terms of India, of course, follows the common law uh, legal system. We have a multi-tiered legal system as well. There's obviously the Supreme Court right on top, then there's the High Court, and then there are several other civil and commercial courts across different levels. Um, to the next slide, please. How do you decide and at which stage does the dispute go to which forum? Of course, the Supreme Court is the apex court with a appellate jurisdiction from certain sets of appeals, and obviously also as original jurisdiction in certain sets of matters, and which is exercises under the special leave petition route. Then there's obviously the High Court, which in most states acts as an appellate court, but in certain cases also acts as the court of first instance in certain commercial and, of course, constitutional matters. For example, courts in Mumbai, Delhi, Chennai, Calcutta, Allahabad, etc., have the original site jurisdiction. Um, and in jurisdictions that don't have the original side, most commercial disputes go into separate special commercial courts, and which obviously were also set up in the recent past to facilitate efficient disposal of commercial disputes. Then there's obviously the lower courts, which are in some cases the courts of first instance, and also the first appeal for a set of civil and criminal cases, etc. In addition to all of that, India also has a specialized set of tribunals, which are largely set up under different statutes. All of them have a very specialized role. They deal in specific specialized subject matters. For example, the National Company Law Tribunal and the National Company Law Appellate Tribunal deals in issues involving insolvency and bankruptcy under the Insolvency and Bankruptcy Code, certain issues arising out of the Companies Act, for example, oppression and mismanagement issues. Then there's obviously also the Debt Recovery Tribunal, which is to assist banks and financial institutions in recovery of debts. Securities litigation and securities disputes go to a specialized securities appellate tribunal. And what's also interesting is that matters that come within the purview of these special statutorily set up tribunals sort of have, in that sense, an overriding jurisdiction on those matters which cannot then be arbitrated. For example, oppression mismanagement in India cannot be arbitrated and would necessarily have to go before the National Company Law Tribunal. The next slide, please. And of course, I think one main reason why these tribunals eventually were set up is also at some level to address the inherent issue that we saw stemming in Indian litigation, or parties in India litigating here, or foreign parties litigating in India, which is the backlog in timelines. So of course there still remains significant backlog, but I think at some level a lot of the backlog has, at least the legislators try to address those backlog concerns by moving certain set of matters away from courts to these specialized tribunals. I think, as I mentioned, for example, oppression mismanagement disputes, insolvency disputes, certain intellectual property law matters. I think the test of what goes before the specialized tribunal and what goes before, say, an arbitrator would be the test would be is it an issue in rem versus an issue in personam, which is basically to say, does it concern the larger public? If yes, then it can't go into arbitration between two private parties. But on the other hand, if it concerns to private individuals, inter se rights and obligations, it goes before that arbitrator, for instance, right? The other obvious offset of a serious issue of backlog timelines was obviously the impetus and sort of the wheels given to the entire arbitration regime in India. Firstly, with of course the updating of the Act back in 1996, and then over the course of time, especially in the last 10 years, to sort of um, arm it with certain tools and certain tools to sort of make things more quick and efficient in that sense. And the idea being to eventually, and when we'll talk about this more as we go, to sort of reduce the reliance on courts and to sort of reduce the interference by courts in matters that parties otherwise have agreed to arbitrate. With that, I'll move to the next section of my presentation, which is the primary question that sometimes we want to answer, which is first and foremost, what are the options that are available to foreign investors investing into India when they're looking at dispute resolution? The second being, which one do you pick when, right? In terms of options, I think, especially in the post-COVID world, where uh, a lot of we see a lot of foreign investors not very keen to go the entire route of litigation. What they try and do, and in fact, not just foreign investors, even domestically, this is a trend that we're increasingly seeing, which is that parties try to sort of resolve the disputes through negotiations and discussions before really pulling the trigger. What that does is that you're still at a point where you're trying to resolve disputes between the parties when there is still some amount of trust. Because what happens is once either party sort of pulls the trigger and say goes to court or commences um, litigation or arbitration, parties tend to be a little wary of each other, and these good faith discussions and negotiations don't necessarily yield the result that you want. So we do now see a fair amount of parties spending good amount of time and energy in the first few weeks of a dispute stemming up in good faith negotiations to try and resolve it. But of course, to say not to say that they always get resolved, and when they don't is when you go into the dispute stage. Uh, where again the options available are as it says on the screen: mediation, litigation, and arbitration, right? Mediation, of course, has assumed a little more significance in the last couple of years, especially with the advent of the Mediation Act, etc. And we'll again briefly touch upon it later. But also litigation, I mean, but also because mediation sort of gives you the option to sort of off ramp from an ongoing litigation and arbitration to try and mediate a dispute. So I think mediation again is something that's effectively being considered by parties today. Then of course there's litigation, which is primarily by which I primarily mean resolving your disputes before courts. The next is arbitration, which still as of today still remains the go-to way to resolve disputes for most foreign investors investing into India. The next, obviously, is what we touched upon earlier, that there are certain specialized forums that are available to parties, but that, of course, gets triggered depending on the nature of the dispute. For instance, foreign investors holding in excess of 10% of share capital in an entity can approach the National Company Law Tribunal for if it's alleging oppression and mismanagement on behalf of the majority against the minority. But again, if the dispute were to be inter se shareholder rights arising out of say an SHA, which doesn't have a larger like the larger company interests at play, those would go before the arbitrator because that's what you're contractually agreeing on, assuming arbitrations is the mode of dispute resolution that you pick. Now, to sort of break these down a little bit for the audience, I think I'll first pick on litigation. If you can go to the next slide. As I said, when we talk about litigation broadly, for the purpose of this discussion, we're trying to look at matters that are pending before courts or matters that happen before courts in India. Of course, commercial disputes before courts are now governed by the Commercial Courts Act, which has a very nice, clear definition of what commercial disputes are. And most joint venture agreements, disputes arising out of shareholders agreement, share subscription agreements, etc., and other contractual disputes and of the like would constitute a commercial dispute in that sense and would therefore automatically go before the Commercial Courts Act, assuming they're above a certain threshold, which naturally in most disputes involving foreign investors, it would be. Um, Courts also come into play in cases where um, there's a litigation that happens in a court outside of India. You want to bring that decree into enforcement into India. That's where courts come into play. But we must be mindful of the fact that India, under its Civil Procedure Code, recognizes only a handful of countries as reciprocal, whose decrees can come into India and be enforced as if a decree of a court in India. Uh, but that's obviously um, another reason why even today arbitration does sort of get picked over court facing litigations. Um, if the decision between the parties is that they will resolve the dispute before courts, I think the key aspect there is that how do you sort of draft your contract to ensure there's no ambiguity later tomorrow. I think as far as court facing litigation is concerned, the two elements you want to be very clear of while drafting the contract is that A, what is the governing law of the contract? The second is which is the court that has exclusive jurisdiction over disputes arising out of the contract. Having said that, unlike in arbitration jurisprudence, in court facing jurisprudence, you cannot confer jurisdiction to a court that otherwise does not have jurisdiction, which means that uh, the choice of jurisdiction should be picked keeping in mind where the dispute's likely to happen. Usually where, there could be two potential places where disputes could arise, in which case picking one in your contract itself means that tomorrow when disputes arise, it's that to the exclusion of the other. But if parties are not mindful of at the time of the contract to pick a jurisdiction which could potentially be where the disputes arises, then the dispute's going to eventually go to one of the courts or whichever court that actually does have jurisdiction. And if there were two courts that have jurisdiction and nothing specified amongst those, parties are free to pick and choose what suits them. That's something that you would ideally want to avoid happening to you as a foreign investor, and you would want to sort of pin it down to a specific court that you believe would be the right court to adjudicate disputes that are likely to arise as you go forward. Uh, Now, obviously, moving on to the more preferred uh, option for dispute resolution, which of course is arbitration. Um, our arbitration law, in that sense, is adopted from the UNICITRAL model law. But over the years, there's obviously been a fair amount of amendments and evolution of the law. A, through amendments, B, also through court proceedings, which have sort of attempted to clarify certain aspects, make things more streamlined, put a certain time bound framework to the process, reduce court intervention, etc. Obviously, the Act per se covers for and looks after both the domestic and the international arbitration framework. Um, One of the most significant amendments that have come in over the last decade or so has been that to open up the interim reliefs regime even in a foreign seated arbitration. Um, Enforcement is another key aspect of arbitration, which at some level makes arbitration a preferred mode of dispute resolution for a lot of parties because a, as far as domestic awards are concerned, the grounds of interference, again, as I said, are minimal. You cannot reopen merits, you cannot reappreciate evidence, and as far as foreign awards are concerned, the grounds to resist enforcement in India are also uh, are less. Even in those cases, you cannot reappreciate evidence and sort of open up the merits of the case. And importantly, India being a signatory to the New York Convention um, allows for awards from a lot more territories being reciprocally recognized in India in that sense. So awards from most of those countries can come into India and be enforced as if an award passed in India in that sense. To the next slide, please. Now, some of the key elements, obviously, of arbitration and other factors that one need to sort of think of at the time at your contract drafting stage to ensure that you build those elements into your contract are obviously the first question of whether you want to pick ad hoc or institutional arbitration. Ketan did an arbitration survey not too long ago, and the response seems to be skewed in favor of institutional arbitration. And that's a trend we've seen change over the last 5 to 10 years, perhaps. Because I think while parties do recognize that institutional arbitration can at some level be a little expensive, but what they do appreciate is that it still puts in place a time-bound framework by which the process ends. It's supervised by the institute, which also means that things happen within a certain amount of with some amount of discipline, and as a result you may be paying more, you may be paying institutional fees, but then the entire process also sort of wraps up sooner. And what helps also is with an institute involved, there's also quality control on arbitrators. There's quality control on the nature of awards that are eventually passed, which eventually end up standing the scrutiny of court, which overall obviously makes the system more efficient entirely. The second obviously is you need to pick what's the seat of arbitration, and I think as disputes lawyers we cannot emphasize enough that the seat is the center of the universe. So I think picking the right seat and specifying it in the contract is key. Um, in domestic arbitrations, our experience is any of the larger seats are preferred and they're good. For example, New Delhi, Mumbai, etc. International seats now. This is important because we have a fair amount of foreign clients who come into us and tell us that look, while we understand that the company we're investing into is in India, and the entire action is going to be played out in India, we would still prefer a neutral seat of arbitration just from a psychological sometimes point of view. And second is obviously also from the eventual recognition to the awards point of view. And therefore we do end up seeing parties now at least gravitating more towards a neutral seat. Earlier the case was you go to the seat of the investor, but now we are seeing the neutral seat coming into play a lot more. Singapore is obviously one of those preferred seats because geographically closer to India, but at the same time a very evolved arbitration hub in that sense. So Singapore is a seat of arbitration that we see a fair bit of. The arbitration institute of your choice or even otherwise puts into place obviously stricter timelines, which makes arbitration at the preferred mode for most parties because the uncertainty of court litigation, the backlogs, etc., don't come into play while you're arbitrating outside of courts in before an arbitral tribunal. So obviously there's shorter timelines. The hearings happen at a fixed usually within a fixed number of sittings. The arbitrators generally appointed keeping in mind the nature of the dispute, so they tend to be qualified to adjudicate disputes of that nature, and obviously the overall convenience to the parties because both in terms of logistics, have an institute oversee the process, and having it done and dusted within a set period of time. I think there are significant advantages to arbitration, and I think we are far from that point where we see people pick the commercial courts to and I mean litigation before commercial courts as the preferred mode versus arbitration. So I don't see that happening in at least in the near future, and for good reason, as I said, with obviously the arbitration regime as it stands today, and with the amendments that are coming into place. The next obvious mode, which we spoke about earlier, is mediation, and on the next slide, please. And with mediation, I think it was something that parties used to explore even earlier, and most of both court as well as the arbitration process sort of gave you off ramps to go into mediation. and a lot of times parties a bit down the road into the dispute would decide to sort of mediate it when they realize that they didn't want to spend too much time and energy in doing it. So I think there was obviously a need to sort of codify it and put a more structure into place, which is what the Mediation Act, of course, does. It gives statutory recognition to mediation. Mediation, of course, is consent based, so nobody's forced to do it, which also means the parties are more open to finding an eventual resolution and they're less at each other. Courts, tribunals have the power to refer parties to mediation at any stage when, as and when they want to. There's obviously full confidentiality to the process. And most important are the next 2 points, which is that A, there's a strict timeline within which this process has to be completed. And more importantly, a settlement agreement arrived at under mediation is enforceable as a decree of court. I think all of this of course, plays a big role in making mediation um, a preferred mode to resolve disputes for parties going forward. And what it does, and I don't want to miss this point, is that it really takes away the concern of time and energy that parties need to put into litigating in India or be stuck in courts for long. I think mediation that way sort of resolves that for you in a much quicker and more transparent manner. The next slide, please. There's, of course, I already mentioned that there's the availability of specialized forums and tribunals for parties depending on the nature of claims that they have and the nature of dispute that they have. And those are also fairly well regulated. A lot of them also operate within certain timelines. For example, the Insolvency Code has set timelines by which the National Company Law Tribunal needs to act, and and I think just generally the availability of a specialized tribunal with a fair number of benches makes it an option for parties to consider depending on the nature of the claim that they have. And of course, you cannot bypass what compulsorily needs to go to those forums. So I think it's also important to sort of understand what the claims are. And one interesting point that comes out from this is why this becomes relevant at some level to the present discussion also is that when you're drafting a contract, you need to also factor in the governing law of the contract, the governing law of the arbitration agreement, and we had a recent case which was in the news, which um, sort of the talking point of that issue became that the governing law of the contract was Indian law, but the seat of arbitration was Singapore. So in effect, the Singapore courts held that the arbitration agreement would be governed by Singapore law. So therefore, an oppression mismanagement issue, um, which otherwise is not arbitrable in India, ended up being arbitrable because the seat of arbitration was in Singapore, and perhaps and for good reason, parties would not have foreseen that circumstance at the contract drafting stage, right? So I think with that learning, it becomes important that um, we factor all of this while drafting the dispute resolution clause, knowing that some disputes are arbitrable in India, some disputes are not arbitrable in India, and factor that in our choice of seat, choice of governing law of the contract, as well as in our choice of the governing law of the substantive contract itself. Um, with that, we'll move to the next section of the presentation, which is just a few practical considerations for parties to sort of factor um, in cross-border dispute scenarios, and more so actually in a pre-dispute scenario, in a contractual scenario, so that you mitigate some of the risks as the matter sort of progresses into a dispute at a later stage. Um, the, the the first and foremost being how do you draft your dispute resolution clauses, and let's focus on arbitration clauses for now, because we, as I said, do see more of arbitration clauses than court facing litigation clauses in foreign investor documents. We've obviously got a more detailed discussion on this on our channel, but just to quickly run through 5 key points that we must bear in mind to avoid what I say litigating as to how do you litigate and where do you litigate. Right. The first is define the scope of reference. For instance, all disputes arising out of or in relation to this contract. Specify that. decide whether you want to pick institutional or you want to pick ad hoc. If it's institutional, specify the name of the institute. Talk about the number of arbitrators who are going to be there. How is the nomination of each of the arbitrators going to happen? For instance, just a ballpark thought: the company appoints one, the investor appoints nominates the other, and the third gets nominated either by the two parties or it could be by the institute itself. Specify that. Specify the governing law of the contract, as I just mentioned in the earlier slide. Specify also the governing law, the law governing the arbitration agreement as well. Usually, I would keep that in sync with the seat of arbitration, but there's no hard and fast rule on that. But most important is specify the seat, because as I said, seat becomes the center of the universe. The court at the seat is what has supervisory jurisdiction over the entire arbitration process. So, for example, your setting aside applications tomorrow would go before that court. Your The recognition of the award would come from a court in the seat. And even at some level, interim applications would be filed before the court of the seat if it's a domestically seated arbitration. Um, Also, whether you want to, as a foreign investor in a foreign seated arbitration, want to exclude the applicability of uh, the availability of the interim um, application mechanism available under the Indian Act. That's also something to be factored in at the contract drafting stage. Though my recommendation is that you should always have that option available for you, especially because emergency awards in foreign seated arbitrations are still not recognized in India. So it may help to not exclude the availability of the interim application channel before Indian courts, so that if you need any urgent interim reliefs, you can approach Indian courts, even though the seat of arbitration is overseas. Uh, Now, why is all of this important is what gets me to the next slide. The idea being that if your contract is not properly and clearly drafted, there's going to be litigation as to what is it that the parties decided, what is it that the parties intended to do, where is it that the parties intended to resolve the disputes, what was the intent of the parties behind what should be the governing law, what should be the substantive law governing the arbitration agreement, etc., etc. I think these things become critical as you move into dispute later. Of course, a few other things that we see come up is whether sufficient stamp duty has been paid on documents. In disputes involving investors which involve a real estate aspect, it's important that parties see that there's clear title to the land to avoid an issue later. Because as I said, some issues cannot go into arbitration. For example, disputes over title of land, etc. And as it is, disputes sometimes take time. So I think it would help if parties define their contracts clearly. They can avoid spending time on litigating on issues that otherwise should be crystal clear from the time a dispute arises between the parties. With that, I think we can move to the next section of the discussions, which is to address a big issue that comes up from foreign clients to us often, which is that has progress really been made in the Indian disputes regime for us to get confidence that it's okay to eventually get into a dispute or a litigation in India? Uh, I will not, I mean, of course, there cannot be a clear answer, but I can certainly say that there has, of course, been sufficient progress that's been made in the last decade to try and answer for some of those queries, to try and improve the ease of doing business in India, and to obviously also enhance our perception globally, and to walk towards us eventually becoming an arbitration hub, which of course is something that we are very keen to become. Uh, Under the Commercial Courts Act, of course, the advent of the act itself was a big progress. It's set up and defined a certain set of commercial courts in India. Commercial disputes have been defined very clearly, and it's introduced a few key features such as compulsory mediation, instituting the suit. With what that does is that it takes an attempt at resolving issues before they eventually go into court, which we spoke about earlier as well. You can obviously skip the mediation stage if you are looking at certain urgent interim and injunctive reliefs from court. But courts are smart in dealing with those where they feel that you file these urgent interim interlocutory applications purely with a view to bypass this process. Courts are not shy to send you back to dismiss the plaint and send you back to the pre-mediation stage. Um, the other big key progress that's been amendment that's come in, uh, fact that's come in with the Commercial Courts Act is the strict timelines as far as written statements are concerned. That's set in stone. 30 with a 90-day grace period. Even courts cannot extend it beyond the 120 days. So I think that's helpful. There are certain strict timelines by which um, post-hearing courts are to file are to pronounce judgments. There is a case management hearing which sets the timelines which are largely adhered to, and I think overall the idea being that you have specialized benches that focus on resolving these in a time-bound manner as quickly as possible. I think the other trend that we're increasingly seeing is that witness action is not conducted in court during court hours, but instead a commissioner is appointed to conduct evidence action outside of the court to sort of save time in general. Uh, of course, that's still at some level. I think the amendments here are, um, while good, we still have to sort of see it play out in a way that it reduces the burden in courts, reduces backlog, and eventually for parties becomes a preferred mode of dispute resolution. Um, but now of course you will understand more of that when I discuss the amendments that have been brought into the arbitration space. We can move to the next slide. Of course, I think over the last 10 years, the arbitration law has seen significant amendments. And I think the key two sort of outcomes of that has been, or I'd say the intention behind that, the two key intents behind that has been A, to reduce timelines. Second is to reduce court interference. I think these two have been the bedrock of the amendments of the last 10 years. Uh, of course, and all of this with the eventual aim to become more arbitration friendly as a jurisdiction, uh, to make the process more fair and transparent. For instance, you cannot have unilateral appointment clauses. The availability of interim reliefs, both from courts and arbitrators. I think arbitrators have now been given the power to grant interim reliefs almost at par with that of court, and they are equally enforceable, even though passed by an arbitrator. There are obviously strict timelines to completing pleadings, completing the hearings, um, extensions beyond 6 months for conclusion of the hearings. You have to go to court. So I think that's in some ways stopping people from delaying things. There's the availability of the fast track arbitration process. There's as I said, while there's supervision, there is minimal interference. Even in challenges to awards, there is no reappraisal of evidence, there is no reopening of merits. But having said that, while of course a lot of these could have just been on paper, I think over the last few years we are increasingly seeing that play out in action as well. That courts are willing to not interfere as far as possible. Most awards are being upheld. Uh, Very rarely do we see an award interfered with, and usually when we do see an interference with, it is usually for substantive reasons, which would sort of go into the root of the issue rather than on reappreciating evidence or opening up of merits. Um, with that, obviously, even we are now, we can go to the next slide where we'll talk about some of the recent amendments that are being proposed. And I think, and what's been positive is that the legislature has been very receptive to what's happening over the last few years, and given that is trying to factor in amendments to make to bring those in or to sort of factor in the learnings from the last few years. For example, statutory recognition being given to emergency arbitrations, virtual hearings, a huge impetus to institutional arbitration, then further fine measures to reduce interference by court in arbitration process include including stricter timelines. And part of this also stems in from the introduction of appellate arbitration proceedings so that most of it gets resolved outside, and when it comes to court, there's only a very limited issue for court to decide, which also means it's quicker and perhaps lesser interference as well. And obviously more discretion being given to tribunals to award costs, which also takes care of any frivolous applications, etc., that may come in. So I think we're looking at these amendments positively, and hopefully we'll see more in the years to come to bring it at par with international standards anywhere in the world, so that India does sort of truly become an arbitration hub where parties are willingly choosing India as a seat of arbitration because they believe that things move quick, things happen with a certain span of time, and there are no concerns on court interference. And eventually, the awards that get passed get enforced and upheld by courts as well. So hopefully, we will get there with each cycle. And I think the last 10 years there've been significant progress, all of which has been positive to get us there. I think with that, I sort of want to quickly conclude and move to the conclusion of the discussions that we had. Um, First and foremost, of course, as we covered, there are multiple options that are available to parties, each with their own advantages, disadvantages. Some of this needs to be factored in at an early stage so that you pick the right option at the right time. Um, Parties obviously need to sit in and consider some of this instead of just putting in a boilerplate clause as used to be the process a few years ago. Um, Of course, while all these options are available, we are largely seeing parties a trying to negotiate, have good faith negotiations and discussions pre pulling the trigger to try and resolve disputes. But once they go into the dispute sort of stage, arbitration seems to be the preferred mode of dispute resolution for parties. Um, Mediation is another thing that's growing. We will see more parties offer mediation, especially with the statutory recognition coming in with the act. But it's critical that we draft our contracts clearly, specify what the intent of the parties is in black and white without leaving any guesswork, and most importantly, engage lawyers well in advance so that they can advise you on different aspects at the right time, and you don't bring in lawyers right when it's time to file your request for arbitrations, because what tends to happen then is that you've sort of lost some ground in how do you want to craft your claims, how do you want to approach a brewing dispute, how do you draft your correspondence leading up to the dispute, and if and when do you want to sort of consider approaching either a specialized tribunal depending on the nature of relief that you ought to go for. Is it worth going into mediation? Is it worth engaging in discussions, good faith discussions, etc.? I think all of this is part of strategy that um, lawyers can sort of bring to the table as and when you see a dispute brewing. I think that's been a learning for a lot of our clients over the last few years, especially in the post-COVID world where you don't where parties are not trigger happy. So I think that's something that one must factor in. I think with that, I'd like to conclude my presentation. Thank you so much. Happy to take any questions, and do write into us even later if you have questions for us at a later stage. Over to you, Sneha.
Thank you, Ravi Tej. Thanks a lot for that very informative discussion. I'm sure that's been really helpful to a lot of people looking to invest in India, as well as more importantly, perhaps their advisors. As expected, we do have a bunch of questions that have come through, which perhaps you can address. Like Ravi Tej mentioned, we'll try and take as many questions as possible, during the webinar. But if not, we will get back to you offline as well. So Ravitesh, the first question that we have is, in your experience, how investor friendly are Indian courts when it comes to enforcing arbitral awards? What are the challenges that you've seen in enforcing foreign court judgments in India?
Right. So, as I said, with the evolution of the Act over the last 10 years or so, and with the proposed amendments coming in, the intent is very clear: minimal court interference. I think that's the mantra that we're trying to follow. Given that, I think increasingly, of course, earlier some of the amendments were more on paper and not be really followed through the T. But increasingly over the last few years, we're seeing minimal court interferences. The trend seems to be towards upholding awards, enforcing them rather than setting them aside. Um, so I think the answer, I mean, the short answer is that we're seeing more and more of awards being upheld, more and more of awards being enforced. So which I think is a good trend.
I'm sure it must come as a welcome relief to, I think, most people tuning into this webinar, because at the end of the day, enforceability of your contract is kind of pivotal to the entire investment. Actually, related to this, and perhaps a question that does come up from time to time, is the next one that we have, which is, can a foreign investor insist on arbitration outside India with Indian parties, and how do Indian courts react to these sort of clauses?
Great. I'm glad someone asked that question just so that we could cover that as well. So, of course, you can insist on a foreign seat of arbitration, right? So these could come up in two scenarios. In a contract between an Indian and a foreign entity, of course, you can choose a foreign seat of arbitration. I think there's no ambiguity there. Even between two Indian parties, now the law is clear. Even two Indian parties can choose a foreign seat of arbitration, and I think we are increasingly seeing more of that, especially in contracts involving subsidiaries of foreign entities, who though effectively are India domicile, but are actually run and operated overseas. So I think they are now insisting that there is a foreign seat of arbitration on those contracts, and yes, so now legally that's possible and enforceable as well.
Understood. So perhaps baby steps in building investor confidence in India, but at least it's one step further in terms of building that confidence, and we will hopefully get to a phase where India seats become popular for India-centric disputes. So taking a slight step away from this, you did address commercial litigation mechanisms, specific court systems set up for it, and India's approach towards expediting commercial disputes. How long does a typical commercial litigation take in India compared to arbitration?
That's a tricky question. And there's obviously there cannot be one answer to that, but if I was to sort of take the easy route out, arbitration overall as a process takes far lesser time than court facing litigation, because with the act and the amendments that have come in, there's still some certainty to the process. There's 6 months to complete pleadings, 12 months to complete hearings, which can be extended by the parties by another 6 months, and every consequent extension goes to court. So I think there's more visibility on timelines in arbitration. I think the general lifeline that we see arbitrations run through is about a year and a half to 2 years. With courts, it could be longer, and for obvious reasons. But where courts tend to be quick and effective is at your interim and interlocutory stage. We've seen parties get relief at an interim or interlocutory stage even within a matter of weeks sometimes. So I think whether to approach court or not, or to go through the arbitration route sometimes could also depend on the nature of relief you're looking at. But yeah, overall, arbitrations as a process takes far lesser time than court facing litigation, at least as of now. So yes, but difficult to put a pin on. It takes X number of months or years.
No, I completely understand as a practitioner where you're coming from. But actually, you answered partially, my next lead up that's just come up, which is, how quickly can parties obtain interim relief or injunctions through Indian courts relative to tribunals? What's been your experience on this front? I think you did briefly touch upon this as well.
Yeah, so I think it depends again on the nature of relief you're looking at. If it's something absolutely expedient and urgent, I've seen courts react even on day one. So I think it would depend on the nature of relief. So I don't think um, I think courts, especially in most of the commercial minded benches, are quite attuned to the fact that there is a need sometimes for urgent reliefs. So, like I said, so we've seen instances where it's happened in days, sometimes in weeks. Um, Equally, the tribunal, right? The tribunal now is empowered under the Arbitration Act to have the same powers as that of court in granting interim relief. So, I think even tribunals, of course, the tribunals have the luxury of just dealing with one matter at a time. which is why that also makes it a lot quicker sometimes than probably court, in some instances than court. But we've also seen a hybrid where you approach court for in an interim application. Courts tend to give some sort of a relief, but eventually send it to the arbitrator to decide it finally. And I think that's also worked very effectively, where the tribunal has the luxury of like 3 or 4 weeks to decide on the matter, but at the same time, the approaching party is secured temporarily by court. So we see a hybrid of that as well. So yeah, so I think um, depending on the nature of relief, we can see courts and tribunals acting pretty quickly in granting them if and when they feel the need.
Yeah, completely agree. In fact, the hybrid model that you've just brought up is something we do, in fact, see very often work quite effectively for complex contracts involving heavy facts. So, again, an encouraging sign for investors who are typically involved in a lot of these complexities. I mean, their interests are protected up front, and the determination can go on. But at least the courts and tribunals, even in India-seated arbitration, I think, are reacting fairly quickly to this. While
That's
interim. Sorry, Ravi.
no, I said that's right.
So while uh, so while of course interim reliefs and enforcement of the awards are things that you want to keep your eye out on and make sure that you have the right strategy, the right sort of contract setup. The best thing for an investor, of course, is to avoid a dispute scenario altogether. So interestingly, one of the questions that's come up is, in your experience, what are some of the strategies investors can adopt at the outset to mitigate or avoid disputes from arising?
So you cannot ever plan to avoid disputes, right? Because you can never stop a party from suing you. But I think a few things that come in handy is, obviously, one is to ensure that you're not stretching the fight over the dispute for years, is to have your contracts drafted very clearly, where the rights and obligations are very clearly defined. Your damages, liquidated damages provisions are clearly thrashed out. Your dispute resolution mechanism is very clearly defined. I think these three things, from a contractual point of view, are critical as and when things move to a dispute. The second, obviously, is something I emphasized on earlier, and as I said, we're increasingly seeing in the post-COVID world, is to engage in good faith negotiations. And the timing of that also becomes critical, because you don't want to come across as desperate. You don't want to also come across as arrogant when you approach it. So I think the timing of that also becomes critical. But I think good faith negotiations are a very effective tool to resolve disputes, because at the end of the day, no party wants to get into protracted, expensive, long litigation. But of course, at times it's inevitable, and I think at those points it becomes really important that your contract, which is the Bible at that point, is very clearly drafted out and etched out.
No, fair enough. Couldn't agree more. Actually, now that you have brought up this interesting angle to, how important good faith negotiations can be early on in resolution of disputes, we do have a question, relating to the Mediation Act. And what is the enforceability of mediation settlements in India post the act having been enacted? Do you see a change in approach of parties as a result?
So it's still too early. It's, I think, a bit too early to sort of give a judgment on it. But I think, as I said, I think the fact that it's consent based, the fact that the mediated settlement agreement eventually holds the value of a decree, I think these are very big and important steps to make it enforceable. And even in our practical experience, we've also seen courts in commercial disputes send parties to mediation before, say, a retired judge or a senior counsel, and those have effectively worked for some of our disputes, and resolved things within a matter of months, which would otherwise take years. So I think I would be fairly positive in my outlook towards the entire advent of the Mediation Act, and believe that it is going to lead to effective and enforceable settlements.
Wonderful. No, that is the intent, and hopefully, parties do use it to good effect in getting there. In a lot of scenarios, we've seen parties waste time and energy getting into a dispute and then settling it. So maybe this provides them a little bit of comfort up front to try mediation up ahead. But coming back to sort of the more established, mechanism being arbitration. So if there is going to be a dispute resolution scenario in disputes involving India or Asia, what do you see typically is the choice of arbitration institution or seat where foreign investors are concerned?
Okay, so I'll break that up into two: seats and institute. In terms of seat, like I said, if it's an India seated arbitration, parties tend to prefer New Delhi or Mumbai. But increasingly in foreign investor foreign investors investing into India transactions, we do tend to see a neutral seat. Singapore seems to be the preferred hub right now. We've obviously seen a lot of London as well, but we're seeing more of Singapore, also because of the geographical convenience between India and Singapore. That's on the seat. As far as preferred institutes are concerned, again, I think the good thing is that most institutions sort of now have framed rules which have tools to make things efficient, with a good degree of sort of supervision into the process so that things move smoothly, and obviously with a good oversight on the kind of arbitrators that they confirm. I think so overall, generally, I think I'm quite positive with most institutions. Obviously, we see parties prefer CAC, ICC. We're also increasingly seeing more of MCIA in contracts involving Indian parties. We also see the DIAC come in, but personally, I've seen the DIAC more in domestic disputes than international disputes, but that's my experience. But otherwise, yeah, otherwise I think we're also seeing some LCIA now. But otherwise, it's mostly it's the usual suspects.
Thank you, Ravi. It's actually really encouraging to see, MCI come into the mix a little bit on international arbitrations. I mean, India is pushing a very strong institutional arbitration agenda. So hopefully, again, that's one of the elements where we, get there in the next couple of years. Um, Coming back to sort of, the setup of the contract as such, you did, through your presentation, flag a few issues on, what parties should watch out for when setting up their contracts from an enforcement perspective. So one of the questions we do have for you today is, what is the best practice in drafting dispute resolution clauses when an investment deal contains sort of multiple agreements executed simultaneously, multi-parties, multi-contract, that sort of thing?
I think, obviously the key elements of a dispute resolution clause we've already covered. I think the idea being absolutely clear and unambiguous. But in multi-party contracts, I think the gospel to me has been symmetry. Just ensure that there's symmetry across contracts. Um, you don't want a situation where different contracts, but part of the larger deal, have different dispute resolution mechanisms, different seats, different governing laws. Because then what you're doing is you have different sets of tribunals in different parts of the world adjudicating on potentially what could be the same issue. So I think to avoid that sort of a scenario, it's important that in multi-party agreements or multi-contract agreements, you should maintain symmetry. I think that's very critical.
Couldn't agree more, Abhishek. Given the nature of this topic, I think we could just go on with like a multitude of questions. But unfortunately, we are running out of time. Thank you so much, Ravi Tej, for taking the time out and taking us through such a well-detailed presentation on sort of what investors should watch out for, what are the pitfalls, what they can do better. I'm sure our audience today has benefited immensely from it. After the webinar, of course, we will be sharing a copy of today's presentation, the materials, the speaking notes, and a webinar recording to all of you. Um, we will also be separately sending you a link for feedback on the webinar. Could we please request our audience members to send us feedback? All feedback is welcome, constructive, appreciative, all of it would be very, very helpful. Thank you so much for taking the time out today to join us, and we hope to see you again on our next webinar. Thanks again.
Thank you.